Now, let's begin. Good evening, all. Hope you all are having a great time. This is Ardra Vivi, and I, on behalf of the whole EETIC family, welcome each one of you to today's session. After your busy schedule of the day, we have all gathered this evening for a very informative and interactive session on IPR. And to enlighten us on this topic, we have got the right person with us. Dr. Anjan Nair, Assistant Professor, Department of Mechanical Engineering, who is the coordinator of the IPR cell CET. The IPR cell, functioning in CET from July 2010, has been providing guidance and awareness to students and being a helping hand in the form of workshop and patent advisors to facilitate the filling of patent application and other form of IPR through PIC Kerala. I welcome you, sir, to the EETIC community and to this session. Without further ado, let us start this session. I am sure you all are excited for this session, and so am I. Over to you, sir.
Thank you, Ardra. I hope I'm audible. Hello, am I audible?
Yes, sir.
Yeah, yeah. Thank you. Yeah, so I think without wasting much time, we will start the presentation. So I believe there are students from both CET and outside CET as well. So anyway, warm welcome to all. And yeah, one second. Yeah, yeah. I hope my slide is visible.
Yes,
Yes,
sir.
sir.
Yeah, thank you. Uh, so warm good evening to all. So we had a hectic day today in the college, and now it's almost 7:15. So maybe I'm planning to take for about 1 hour and maybe like 10 minutes maximum. So the topic given to me is introduction to intellectual property rights, popularly known as IPRs. And I'm sure most of you might have heard the term patents and things like that. Uh, uh, so that's why an interacts that the heading has been given as an interactive session on IPR and patent filing. Okay. So we'll focus more on patent, but I will cover all the IPs basically connected with this. Okay. So sorry, I'll just mute my video because it might take a lot of data. So yeah, one second. Yeah. So sorry. Oh, can you just give me a minute? I want to just close this and again join. Okay, fine. I believe many of you are from or interested in electronics, electrical, and other community. Those basically, thank you ET committee for arranging this talk, and also many of you might be no, uh, working or interested in coming with startups and things like that, or having your own company within a few years or very soon. So in which case you should be aware of all the IPs that are connected with this. Okay, all the different types of IPRs which are inventions, we have patents. So we will cover all the aspects. So we'll start with a brief question. So who is the inventor of telephone? Can one of you just you know, unmute and tell the answer? So I think our session is supposed to be an interactive session. So don't let it let's make it informal. Just one of you, just unmute and tell the answer. So who is the inventor of telephone? So this, as an electronic engineers, you should be able to, or you should say the answer quickly. So this
Graham
will be your
Bell.
step.
Sir
Yeah, yeah,
Alexander Graham Bell.
yeah, correct. So two of you have answered. Alexander Graham. Similarly, can you tell who is the inventor of electric bulb?
So Edison.
Yeah, yeah, very good. So, can you tell me why you have given these names, Alexander Graham Bell and Edison? Is it because your textbook says so, or your teachers told you that these are the people? But how do you know for sure that these two persons are behind these inventions? It could be somebody else also, right? Somebody else can come and say tomorrow. Somebody can come and say, no, we were the original inventors. So, how do we counteract to that? So for that, we have an IP known as the patent. Okay, so patent is basically a techno-legal document. Okay, which gives or which tells us who is the inventor, who has created that. So it's a legal document, and at the same time, it's a technical document as well. Okay, and you can see here on the screen on the left figure. So the left figure is the one which shows the patent application for the telephone. And you can see here below the name of Graham Bell is given here, and it was awarded in 1881. And similarly, the right hand figure here, the second figure. So this one is for the bulb. Okay, and this is for given to, you can see, Thomas Alva Edison, again in the year 1882. Okay. Uh, and so this document, this is the, you can see on the top, the heading, the United States Patent Office. So these patents were awarded in United States. Okay, so this gives us an idea that, okay, these are the persons who are involved behind these two inventions, and that's why we give credit. So that's it. So again, so with the permission of all participants, just can you give me 1 minute to just there's some technical problems, so with the permission of all, just kindly excuse. I'm sorry. Yeah. So I hope the screen is visible. The
Yes,
paper.
sir.
Yeah. Thank you. So basically, what is an intellectual property? So intellectual property is something that is produced using human intellect and has commercial value. So it's a product of mind. Okay, and how does basically the intellectual property law work? So basically, it helps the owner to file a lawsuit against a transgressor. So if somebody else is coming and claiming that it is their invention, you can file a case and say that no, this is mine. Okay, so that is the basic concept behind all the intellectual properties. Then basically it is territorial. So we have seen in the previous slide here for the patent. So you can see it is United States Patent Office. So it's territorial. So basically keep this in mind. All IPs are territorial. Just like, for example, in our case, your vehicle. Most of you might be having a two-wheeler or a four-wheeler, a car or a scooter. So how do you know that you are the owner? So for that we have the RC book of that vehicle. So RC book is again is valid only for example, an RC book in India is valid only in India. Okay, you cannot take your vehicle outside. Even for that matter, even an RC book issued in Kerala, okay, has validity only in Kerala. You cannot admission from the motor vehicles department from Tamil Nadu. So that is from another state. So that same way, this all the IPs are very territorial. Your patent or what trademark or whatever you have obtained is valid. For example, you are taking it in India. That means it's valid only in here. You cannot claim that IP in another country. Only thing is, the in that country the patent cannot be filed. Another person cannot file that patent. Okay, but it cannot prevent you from that person, you any person in a foreign country from not making that product. Unless if you want to stop that, you will have to take that patent in that country as well. Okay, and basically once you, so what's the benefit of getting an IP is you are giving the given the sole ownership of that intellectual property for commercial exploitation. Like you can sell, you can license it, you can lease, you can assign your this thing to somebody. So these are the advantages. So basically always keep in mind that all IPs are having a commercial aspect also. Okay, so it's an no, generally we say how, what are the ways of making income. Most of you might say it is by getting a job and getting a salary, but IP is also another source. By having an IP, especially in the case of patent and thing, it's a way of getting an additional income. Okay, but of course that your patent of course has to have some commercial worth and things like that. Even for any invention you might get a patent, but again the if it is not no, worth for a large commercial no, distribution, then you may not get that much money. But otherwise by having a patent or a copyright, you are getting a commercial value also. So it's an additional source of income for you. Okay, so we'll quickly see what are the different types of IPs or IPRs. So basically we have patent, then you have trademarks, then you have geographical indicators, industrial designs, then industrial sorry integrated circuits, copyright. So basically copyright is basically for literary works, things like that. While for the industrial applications we have these other six or seven types of IPs, and this eighth one is the copyright. Okay, so basically eight types of IPRs are there. So we will quickly see one by one. So before that, the structure of the IP office. So basically in India, it comes under the Ministry of Industry and Commerce. And under this ministry, you have the Office of the Controller General of Patents, Designs and Trademark. And they have different offices, for different type of IP. For example, for designs, we have in Kolkata. For patent, we have in 4 offices: Kolkata, Delhi, Mumbai, and Chennai. So for South India, for Kerala, for example, somebody from Kerala, we have to file for example, if you want to file a patent, we have to file it in the patent office in Chennai. Okay, so similarly for trademark, you have in Kolkata, Delhi, Mumbai, Ahmedabad, and Chennai. For GI, it is in Chennai alone, and there's a additional patent information service center which is there in Nagpur. Okay. So first IPR that we'll discuss is the patent, and I think most relevant, especially for an engineering students like you. Okay, so basically patent is for inventions. That is the clear-cut demarcation. So if you have some product invention, okay, process, even for a process, okay, so in which case you can file a patent. So it gives again the legal right to make, that is manufacture, use, sell, and even prevent others from uh, copying or transgressing your invention. And there is a time period also. So this patent is valid only for 20 years, after which it comes into the public domain. So if you want to know, so that is again another important aspect. If you have some product and very good idea and you want to make a product, immediately file for a patent. But again, you have only time period of 20 years. So once you have got patent, that legal validity is only for 20 years. So immediately commercialize within that period of 20 years. After that, it comes into the public and you have no more control after 20 years. And as I told you, it's territorial. So you have to file patent in one that particular region alone. For example, India, you have to file one patent that will be valid only in India, not in other countries. Okay. As I told you, for example, in China or Pakistan wants to copy our invention, it is given by the National Patent Office. Okay. So what can be patented? Basically, as I told you, in all inventions, and there is some exceptions also for this. That is Section 3 and 4 of Indian Patent Act of 1970. So we'll see what are these things one by one. So before that, So what is an invention? We'll see the definition of an invention. So as per Indian Patent Act, so we have an Indian Patent Act, there's a law separately for patents, and anything which is new, so new can be a product as well as process. Okay, so the mobile phone that you are using is a product. Now how you manufacture that product, that is also, that is called as a process. Okay, so you can even file patent for process also. Okay, so it is for both product as well as for process, and it should be inventive, the new or novel. Then the second should be, it should be inventive, and the third and most important aspect is useful. So when you're filing a patent and it goes to the patent office, they will check whether it is useful to people. Okay, so that is the main point they will check. So if you are filing a patent and if you are filing a patent and to your invention. Okay, you know, it's basically varying, but most important thing is whether it's useful to people. No, it should not become by creating that product should not create more trouble for the end users. That is the main point they'll be checking. Okay, my commercial value can vary. I mean, you know, some things can have very high value, some cannot, but more whether it is useful or so new and novel, how do you determine whether it's not new and novel? So it should not be published before in India or anywhere else. So that's a keyword, anywhere, and that is not published means. So this is something very 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 important. All students now who are interested in filing patents, okay, you should keep this mind in very much that you should not publish before filing for patent. Okay, patent filing may take anywhere between 3 to 6 months. No, you can even no, it will not, it all depends on you and who is filing that. So you have a lot of documents to prepare and things that. So if you are doing it quickly, within a very short time, 1 or 2 months also is enough, more than enough for filing, and immediately you get a patent number. So for example, if you are filing patent this year, you will get a patent number starting with the 2022. And for example, in CET, for CET, since we are already filed some 15 or 16 patents, so we have a exclusive number for us. So that is 410. So 2020 2022 410, and then some 5-digit number will be there, which is exclusive for the application number that year. Okay, so that is once you get that number, you can then go for publishing. Many students and even many faculties and many other inventors make a mistake. Okay, especially in an academic institute, because we are in a hurry to publish and things like that. So we immediately will file in some, or rather we will, before filing itself, we will publish it in some journal paper or some conferences or some textbooks like that. Okay, and again many may make a mistake by taking part in technical competitions and without getting proper signature or non-disclosure forms. They will reveal the information present in front of public or give it in newspapers. So recently something happened in electronics department. A very good invention was there. It had a novelty, there was inventive step, then there was a useful or industrial application, very good commercial value also. It could have been released as a product, but unfortunately they were in a hurry and they published in the newspapers and all leading journals. That is the unfortunate. If it was just some in, in our vernacular press, in the Malayalam press, it was okay, maybe we could have somehow avoided. But it came in all the leading journals or newspapers in India, Hindustan Times, Times of India, Hindu, all the papers. So we lost that novelty component. So you should, the secret part, there's a secretive part. So you should not reveal before filing. Once you get the patent application number, then you can publicize things. Then you are safe. But before, if you are going, that the novelty has gone. You yourself have published. So where is the novelty? That the patent office will immediately reject if you have published it. So this is a very important thing which you should always keep in mind. And their second point, as I told you, should be have an inventive step. So it should be non-inventive. So the mobile phone, again, I will give you the example of the mobile phone. So it's a phone. So we have seen the example. The first telephone was patent was granted to Graham Bell. So this is also in a form a telephone, but how then the invention has come. So basically, over a period of time, a lot of changes have taken place in the original model. We are not using the telephone of Graham Bell's model. That is not that model we are not using. We are now using smartphones, touch screens, and things like that. So those are the inventive steps that have taken place over a period of time. Okay. So in your again your mobile, again coming with the example of mobile phone, you can have a switch button, okay, at the bottom. Some other company, for example Samsung, has come with a mobile phone with a button at the bottom. Now Apple comes with a button on the top. So that is not no inventive, because it's an obvious thing. Just you have changed the position of the switch from top and bottom. That will not be applicable, okay. But rather from the old mobile where we had all dials which were touch type, or sorry, were button type, now we have come to a completely touch screen. So that is an invention, okay. So that is what you should keep in mind. So that is the second point. And third, as I told, must be having industrial application. That means it should have usefulness and utility. And fourth, of course, I told, it should not be covered in section 3 and 4 of Patent Act. So novelty, as I told, not published before, not in prior knowledge, not claimed in any patents, okay, in any country, okay, and not in prior use. So many times has happened. So I'll give an example of this also. Sorry, inventive steps. So these are all I've given. So let's not waste. So some, as I told, section 3 and 4. What are the things which inventions which are not patentable? So first thing, again, like I told you, any invention which is violating any laws of nature. Okay, so I think many of you have studied in your thermodynamics, especially if you have studied basic mechanical engineering, or even in your plus 2 physics. So you have the first law of thermodynamics and the second law of thermodynamics. So these two laws, that is energy can neither be created nor be destroyed, and second is the violation of entropy, okay, or increasing of entropy. So these two concepts basic, and apart from that, gravity, okay, all these things. You cannot come with an invention says which is violating these natural laws, like energy creation or mass creation, or gravity defines gravity and things like that. So it should not violate any natural law. So that is the first thing they will check. And again, just scientific principle for formulation of abstract theory. This is again thing many students come, okay, I would derived a new equation or a new mathematical forms and things like that. Can I get a patent for that? No, you cannot get patent for these things, okay. And just coming with a new property or use of a non-substance, okay. So there are so many chemicals available. For example, benzene is there, and you say, okay, benzene can be used for a new application for in the cleaning of the mobile phone. No, that is not that will not be awarded, because benzene is already existent. You cannot, just because you have found a new use, you will not get a patent. Then again, mere use of non-process machine or apparatus, again self-evident. Just by mixing two more components and forming a new thing, no, you will not get patent, unless of course you validate why this mixing combination you have selected. Then mere rearrangement of duplication of known devices, agricultural methods will not be given patent. Method of treatment, okay, of human beings and animals will not be given patent. Plant and animals. So for plant and animals, we have a separate IP is there. So that will be discussed. Okay. Mathematical business method, computer programs. So this again is something very important. Many students come with programs and softwares and things like that. Okay. So this, please keep in mind, in India, okay, patents will not be granted to computer programs or algorithms. US, I think it is allowed, but not in India. Here, you can get a patent for a computer program or a software if your program is integrated with a hardware. Okay, so there's a hardware component is there, and you claim that the hardware cannot run on its own without the software that you have developed or your code you have developed. Okay, then you can claim a patent. So it will be a combined one for the hardware alone. For the software alone, we in India, patent is not enough. Instead, you have to you can apply for a copyright. So you can see most of the softwares and websites and things, you can see in the bottom there is a copyright signal, this will be given. So that is why these are the only copyright can be awarded for these programs and things. Then mental acts, playing games, this will not be given patent. And so these are all basically section 3 so on which will not be given patent. Then the last one is section 4 is anything related to atomic energy. So in India, we have the Department of Atomic Energy, and anything related with atomic and nuclear energy, this will not be granted patent. Only DAE will be allowed patent for that. So these are the conditions. So we'll see one example quickly, which will help me or help you understand whether you have got the concept behind this, understood the concept behind this patents. So you can see on the screen, this person is having a bicycle, and see he has folded this bicycle and locked it to a pole, okay, or some electric post or something like that, or telephone post or something like that. Okay, so can this be patented? Can one of you uh, answer? So let it be right or wrong. So from the concept, so I'll make it a little more easier for you. How do you know whether so apply the principles? Okay, so how do you know whether a thing can be patented or not? So first is whether there is a novelty. Second, whether there is an inventive step. Third, whether it is useful. Okay, anyway, the fourth section 3 and 4 is not applicable here, so that you can erase. So the other three principles just apply. So this, have you seen this before? This concept, is it novel? Do you feel that this is novel? Has it been published before? Have you seen this in any journals or no?
No, sir.
Can one of you answer? Let it be right or wrong. So this is supposed to be an interactive session, so you should you should answer. Okay, nobody's responding. Can one of you just tell? It's okay.
Patentable, sir.
Yeah. So there is a novelty component is there, right? Yeah. So second is inventive or a non-obvious. So nobody, I'm 100% sure. None of us might have thought about this idea. All of us were having we have a lock cycle. Traditionally, cycle lock is there, but no, cycle lock can be easily be broken. Okay, so a lot of cycle thefts happen in India, or even worldwide also for that matter. So this then has come as the new concepts. This is not easily be breakable. So and this new concept of the cycle itself being locked. So this is a novelty is there, and is it useful? Yes, this is useful. We need this. Okay, so we'll see. So novelty, yes. Inventive, yes. Useful, yes. So yes, this is a patentable. Okay, so this is one example. So one more example we'll see. Okay, so this was an application received in the patent office. So the original diagram that I told you, patents are basically techno-legal documents. Why it's called techno-legal document? Because there's a legal aspect. Because if you want to file case and things, this is our document in the court. And technical, because I like any technical document, like your project reports and things which you prepare, it will be having some drawings. Engineering reports should have a drawing, an abstract specification, what are the components involved, and all those things will be all technical aspects of the method and things all should be there. So here you can see all this drawing is there. So what is this invention? So basically, no, smoking is a big problem. You see, go to the theaters and they say, okay, എന്താണ് ശ്വാസകോശം സ്പോഞ്ച് പോലെയാണെന്നൊക്കെ പറയുന്നത്. So you people want to, that may not addiction is, I'm sorry, addiction is there. So people may not be, just by seeing an ad, people may not be able to stop. So some technique to stop smoking. So you can see in the hat, there's a mechanism. There's a pressurized cylinder is there. Okay, and there's a sensor, heat and smoke sensor is there, and a nozzle is kept, and there's connected to this pressurized cylinder. These two are connected to this. So suppose somebody is lighting a cigarette, so the smoke and heat will be detected in this by the sensor. The sensor will tell the pressurized to activate, and a foam, okay, something or a liquid will be dispensed from this cylinder, and through the nozzle it will be sprayed. Okay, so by that you are extinguishing that fire and the cigarette itself. But it is also, the foam will be also falling on the face. Okay, so can this be patented? So now apply the concept. Is it novel? Is there a novelty in this? Have you heard read about this anywhere? Yes or no?
No, sir.
Yeah, so there's a novelty is there. So inventive, So yes, there's an invention, right? So there's a which was not present. Nobody has used a hat to kind of for this. So an inventive this. Is it useful? So that is a tricky question. So yes, in a way, it helps you to prevent the smoking. But then the problem, what is the problem? So you have all the foam and this liquid is just sprayed on your face as well. It's not just on the cigarette, but on your face, your hand. It creates a mess. Okay, and suppose you are in some clubbing and front of people, now you end up like looking like a clown, having all that spray on that face, all the liquid on the face, so it doesn't look good. So in that sense it's not useful. There's a purpose, there's a good aim or objective behind that invention, but the end product is not useful. Okay, the utility part is not refined properly. So as per the patent act, you cannot be, so this is not patentable. Okay, because one component, this the third, so these all the three criteria, so it basically and criteria is applied for all these things, not or. So all the three criteria have to be satisfied, then only you will be given patent. Okay, so with I hope the concept is now very clear how to, regarding patents. So basically for inventions, there's a territorial aspect. Okay, then there's a term of 20 years, and basically three criteria, majorly three criteria. These three criteria have to met, and of course section 3 and 4 we have seen some conditions are there, that is also to be met. Natural law violations and things should not happen. Okay, so with this, so again, like I told you, one of the objections in the section 3. So one very famous example, most of you might have heard in newspapers and other things, media, of turmeric. So turmeric is has been used for an ancient time from in India, in especially in Ayurvedic and naturopathy for treatments, and basically it has a very good antiseptic properties. Okay, wound healing ability is there, and it's a natural product. And unfortunately, to two Indians itself, from India, they had settled in USA, and they tried to get a patent for this. So, and actually, unfortunately, it was granted also patent in US. Then we were caught sleeping basically. Later we realized that this is has happened. Then we, of course, we all raised a lot of hue and cry cases. CSIR, there's a Council for Scientific in Industrial Research, Delhi, filed in US patent a complaint saying that turmeric has been used for thousands of years. So they quoted many Sanskrit textbooks, especially Ayurvedic manuals, old manuscripts they brought. And also there was an article, fortunately for us, in because of course US patents, the Sanskrit and things will be difficult. So in 1953, fortunately, a Journal of Indian Medical Association had a published an article also on the benefits of this turmeric, and therefore the patent was rejected later. So it was a granted patent and then it got rejected. Okay, so this again, as I told, many common inventions, which has been used from a long time, but that can also not be granted patent. So these are the patent offices, some pictures. And so what are the documents required for filing? So these are the basic documents. Form 1 is there, you're in 2 copies, that is application form. Form 2 is a provisional certificate, that is if you want to. Yeah, we'll come to that later. So many time what happens is, when you have come with an idea, or you're almost with a product is there, but still you want to still play with it, and some more ideas are there. You feel that to get patent, because similar products are already there, but to make your invention a little more stronger to for claim in patent office, you might need some more time, in which case can apply for provisional patent. Can be, so in provisional patent you get 1 more year, so you file it. Okay, and you get 1 more year to finalize your product. So that time you're basically buying time. Okay, but again, as I told you, it's only for 1 year. So within 1 year, then you have to then file the entire application. The other one is, if you are initially, you get sufficient time to later make even some changes and things. In provisional application, what will happen is, after that you cannot make any more changes. Okay, so the patent officer can reject, later will reject drawback with you get time for 1 year. But then so many companies, basically I told you, patent is for creating monopoly. Many private companies, for example, Samsung and GE, they have offices in India. No, they are not making any products actually, but they have the entire team of engineers and patent experts who just create, file patents non-stop, so that nobody else will come into that field. For example, Samsung has some like 1,000 patents filed, of which only 20 have come as an end product in market, or 20 or 30. Just I'm giving a rough idea. Okay. But the other 1,000, or almost roughly 900 or 950 patents that they have filed will prevent any other companies or inventors to even reach anywhere near its products. So that is both the advantage and the drawback also for an individual inventor. For corporates, it's actually kind of supporting in that sense. Then Form 3 is undertakings, and then Form 5 is the declaration of inventorship, and the last Form 26 in case you are filing through an attorney. So just I think if some of you might have gone to what is called as your revenue officer Adharam. For example, in our house, or for buying a house or land, you have to register the revenue office is there. So there, what you call as in Malayalam Adharam എന്ന് പറയുന്നതല്ല. Adharam എന്ന് പറയുന്നത്, that's a document which says that you are the owner of the land. So that can be written, the title deed, what is called in English called as the title deed. The title deed can be written by yourself. So if you are the owner, you can also write it. But most of you might have read your title deed or something else, wherein they use legal languages, or like first respondent, second respondent, first party, second party, then all those things. Even for rent, you would have seen some languages, tenant and this thing and so many things. The specialty of the legal documents, so that nobody can easily break into it. So that legal term is there. You might come with an invention, a brilliant idea, but no, there are people who are already working, and they know how to break into this and come with their own invention. You might have come with the original invention, but they can read it, they can make changes, suitable changes, and come with new claims and come file. So whenever you are filing a patent, you should close all the loopholes. Okay, your invention should be, all the claims that you're putting in your patent document should close all the loopholes and be solid. Okay, so in which sometimes, because we are inexperienced or we are naive, we don't have the crooked mind. So so people who are expert in this have that, not in a positive sense, I'm saying, basically lawyers and things, they see all the loopholes and they make a document. So in that case we can, so it's always advisable to have a patent attorney. As I told you, you can always do it on your own. There's the Indian Patent Act gives you full right to that, but you might fall into some trap, and or you might file the patent, you might even get the patent, but then it might not have that much commercial value as which you thought. Somebody will just come with another patent which is more solid than you. So prevent, to help in that sense, we can file you have patent attorneys or lawyers who have specialized in patents, and you have even patent agents. You not pass law or LLB or anything, but just pass the exam conducted by the Indian Patent Office. For that you get an certified, you become a certified patent agent. Okay, that you can, then which you have to give the power of attorney. So he is going to file on, or he or she is going to file on your behalf. So that is fun. And you can pay fees by DD, check, cash, and now online mode is also there. This office of the patent office on the website, you can file also directly. Okay, the procedure: you file the patent. Once you have filed, it sometimes takes anywhere between like 1 year in this publisher is, there's an Indian patent journal is there, exclusive journal for the different patents. This is what no, as I told you, patent in one way you are giving all your information. Okay, initially I told, yes, there's a secretive part, and yes, that is before filing. But once you have filed, actually you are giving your entire information or of the invention in public domain. So in order to get that ownership or inventor status, You're actually giving that. So in which case, so when you're given this, people can complain. So people should be aware that you have not copied their invention. For in that sense, you have the office has a patent journal in which this details of your patent will be published. So that is this publication. So people will be, many companies are constantly in lookout to make sure that nobody is copying their inventions and things. Individuals may not be behind this, but the corporates are always behind this. Then request for examination, you file. So once this is published, then you file for examination. So there in the patent office will have some experts. They will then file, they will examine your patent, and they will issue what is known as an FER, first examination report. FER, just like in police station where an FIR, you have an FER, which is based on the experts. They will view your inventions, all the details. They will verify all the details, and if they feel that it is worth, they will give all their comments. So some critical comments they will give. So this yes, novelty is there or novelty is not there, whatever maybe, they will give the comments. Then you have to give reply to that first examination report or FER, and if the reply is accepted, you are granted patent. And but if it is the reply is not, then again it has to be some objection, minor objections there, then again you can make the changes and again send it back for examination and things like that. So you find again in olden time, up to 2007, just been made. People, even after granting patent, no, sometimes people may not be aware, when may miss out in the publication stage. Only after it has been granted, people, okay, oh no, this invention is already there and things. So people can raise complaint, in which case again it will be sent to the opposition board. They feel that okay, the patent is existing, then it will be rejected. Okay, otherwise sorry, if the complaint that has received is not valid, then the patent will exist. If the complaint is valid, then the patent can also get rejected. Again, you can, as an inventor, you can even again one more step, file an appeal to the higher authority. IPAB is there, that intellectual property appellate body is there, saying no, an injustice has been done. If and they will again check everything, and they will also verify. So, and if once they have finally given an opinion, yes, this is can be patent or not patent, that is the final. So these additional stages have also come into the patent filing procedure in India. So this is the fee structure. So this is actually old things, we will not go. So now good news is for, especially now as an educational institute, now the old fees, as I told you, was 8,000 rupees for filing patent. Now it is only 1,600 rupees. Okay. Publication earlier it used to cost 12,500 rupees. Now it is only 2,500 rupees. Then request for examination was 20,000 rupees. Now it has been reduced to 4,000 rupees. And expedited examination, if you want, 60,000, and now it has been reduced to 8,000 rupees. And similarly, if patent renewal, you have to renew once you get your patent. It's not that the end of process for 20 years. As I told you, the patent is granted for 20 years. But again, that is not initially itself. You are not granted unless, of course, you pay the whole amount. You can renew every year. So for up to the 20th year, you can keep renewing each year. Earlier, it used to be like 4,000 per year for renewal of patent once, even after you got the patent. But now it has been again for educational institutes and also for startups.
Excuse me, sir.
Yeah,
Sir,
yeah.
your voice is breaking.
Okay, okay. From which point onwards was the problem?
Sir, last point.
Okay, regarding the fee structure, alle?
Yes, sir.
Yeah, just can you give me 1 minute? Yeah. Am I audible now?
Yes, sir.
Yeah. So as I was telling you, the patent fees for educational institutes have been reduced as per this. No, so all these rates you can see almost by 1/5. For example, patent fee filing fee was 8,000. Now it is only 1,600. Then the publication fee, even for publication you have to pay the fee of 12,500 was the original fee. Now it has been reduced to 2,500. Then request for examination, for getting that FER report, was 20,000 earlier. Now it is to 4,000. expedited, this has reduced from 60,000 to 8,000. Then patent renewal is there. Okay, so as I told you, patent is valid for 20 years, but it is not that once you are granted patent, that is it. No, every year actually you need to pay a fees to claim or that patent is yours. Okay, so for 20 years you have to keep on paying to the patent office to have a claim on that commercial value on that patent. Patent will always be yours, in the sense the inventor right will be, or inventor name will be always yours. But for commercial aspect, if you want, you need to pay an amount every year. Earlier it was reduced to 800 rupees per year. You have to pay for up to 20 years. You need to pay to have that patent ownership. Okay, so renewal fees also is there. That's another important aspect which you should keep in mind. Okay, so do's and don'ts. Immediately file for once you have an invention, novel invention, do not publish or give publicity before filing. Do not delay filing in this. Do not reinvent the wheel. Do not file patent without ensuring that the invention is worth getting patent. Do not hide any invention information from attorney. Do not display invention in public. Okay, do not forget to pay renewal fees. That is if you want to have the rights on it. Do not be satisfied patent certificate. Okay, so as I told you, this is a patent certificate for our college. CET we had got for an electric vehicle. This is just a certificate. Now it, as currently it is just a certificate which has been framed and hanging on in the principal's office. But that is not the end purpose is not met. The patent has to be finally come into a product and have some commercial value, something useful to society and things like that. Also has to be taken care. Okay, so this is what I know. And another important thing is, people feel that patent is for some big things, so complicated, Nobel Prize winning, nothing. So patent is for even small things, some new inventing things you have done. For example, you have 20 patents for a safety pin for zip. No, all these had patents, rubber band, this paper clip, these all had a patent was filed. Okay, so this is something a small innovative step, but it should not be obvious. That is the only aspect we should keep in mind for filing a patent. Okay, yeah, some useful links are there. Go through maybe these sites. Links are there. And another, so suppose many students may now coming with projects and things, and if you want to assess okay, one useful tip I can give is Google Patents is there. Okay, just like Google Scholar and other things are there, there's something called as Google Patent. And in that Google Patent you can type your invention details. Don't use the exact words. You might have come with some fancy terms, but try to use synonyms also, because that's how people. I'll give you an example. For example, teapot. Okay, so you can file a patent for a teapot. Okay, and unfortunately there will be like 100,000 patents will be already existing, and immediately if you file with a title teapot, then it will get rejected. But you come with an alternate name like a liquid dispenser for dispensing of hot fluids, and then you can file for patent. The patent office will, okay, oh, something new knowledge there seems to be there, so that's what I said. This legal term is there, so legal, so coming with new words, synonyms, and then search and Google patent, you'll get all the lists. So it's also a good idea, a way to generate ideas. Okay, Google patents, you some idea, for example, drones. Many of you might be working on drones and things like that. So you can just Google search drones. Okay, and like more than 1,000 patents you can find in that Google patent site. You will get the links will be provided. Download those PDFs, go through those drawings, the inventions, see what are the ideas they have used, and by going through some 10 or 15 documents, you yourself slowly start developing new ideas. Okay, oh, these are the inventions already existing. Why don't I make some new changes or take some idea from this and develop on it? And this so filing for this using Google patents is a very good idea to generate new ideas. Okay, so use that concepts, and these sites are also there to search whether you. we are finishing the first IP, that is the patents. Now, second IPR is the copyright. So copyright, now these things I'll go fast. Okay, so copyright is basically for literary works, then artistic works, cinematography, films, records, and things like that. So books, you just go through any novels or books, or even your textbooks. Okay, standard textbook, you can see there will be a notation C in a circle. So that is copyright. Okay, so books, for when you're writing books, novels, textbooks, things. Yeah, then music. Okay, you come with a new music, Rahman comes with a music, he will copyright his music. Okay, sound recordings, cinema, movies, all movies will be having a copyright, will be has to be taken. So basically, exclusive right granted to the owner of a literary, artistic, or scientific work to use or authorize others to use it for its reproduction, public performance, translation, and adaptation. So once you have a copyright, because suppose so many novels are there, so people can just straight away copy that novel and things. So to prevent that, we have this copyright is there. But copyright is not that strong law, especially in India, when compared to the patents is a very strong, you can be arrested and all those aspects are here. Okay, you because of the legal procedure in India, it will take a long time for legal case and things like that. And finally, of course, still that doesn't mean I'm not in no way trying to discourage you. If you have come with any textbooks or softwares or any more sound music or recordings or movies, or please copyright that also, so that people not directly lift, they cannot directly lift, of course. Now especially Hindi movies, you can see Hindi movies, the story is always the same, or especially romantic movies. There's a love story between a boy and girl. Either it will be a rich girl, poor girl, or a poor boy, a rich boy. So some stories are there. So the copyright is then is then how to prevent others to copy as per se. So there are movies, many of the Malayalam movies now are being made into Hindi, and so because they have taken the copyright, they cannot lift the story as such without taking the permission of the producer or the directors, who had the copyright. So they can adapt the story for their language after taking the permission, and of course by paying some fees and things like that. So in that, that's why I said copyright is required, but no, people can make some small changes and claim a new. You cannot lift words or no sentences as such from the books. That's the only way you can prevent it. In music, also the same tune as such, you may not be able to. But some minor variations, here and there, you cannot prevent. So that is both the plus and minus of copyrights. So all this. These are examples of this novels, diaries, dance performance, photographs. I'm sure many of you are good photographers and things like that. So your photographs and things, you can copyright. Okay, the photos that you have taken, novel photo, very good photos you have taken, you can take a copyright. Okay, again, basically, there's a term. Okay, so for literary works, it's lifetime of the author. So if the author till that is that you have written a book now at the age of say 20, till you die, you have the copyright with you, or 60 years following the death of the author. So you can even transfer your copyright to your legal hair. So your children or grandchildren, you can pass on that copyright. Okay, then cinematography, that is movies, it is 60 years from the year which it was made. Then TV, in the case of TV, it is for 25, right? Rather, TV and radio both broadcast, so it's for 25 years. Something, no, a new serial or something which you have made in TV, for TV, the right is for 25 years. After that, you can transfer your copyright. So this is a term. And you have to pay basically for books and other artistic, it's a nominal fee of 500 rupees, and you don't have to go to any legal lawyers or for this copyright. You can straight away just there's a form which can download from website and send it to this office. You will be granted the copyright. Okay, so don't spend any money for copyrights. And for patents, you can take an advice, that is always good. Some spending some money is okay, but not for copy, not worth for copyright, because the form itself is just 500 rupees. Okay, so for movies it is 5,000 rupees, sound recordings it's 2,000 rupees. Okay, the third IP is trademark. So as I told you, many of you might be starting some company, or so it's, you need to have a trademark. So what is trademark? So a distinctive sign or indicator, and to identify, no, basically to give a unique identity of a product. Okay. So it could be either one or combination of letters, words, or numerals. It could be drawings, symbols, 3D signs, audible signs, okay, fragrance, colors, all this kind of. So many of the new perfumes, no, those they also try to get the, for the smell also they get trademarks will be applied. So you might have seen in many of the products this notation R in a circle. So that is basically trademarks. So trademark, sometimes they even use TM mark will be there in a circle enclosed. In the other one, copyright, it is C enclosed in a circle. Similarly, in the case of this trademarks, it is either TM or it could be R. Okay, R is when you this trademark has been officially registered with the IP office. It has been they have granted you, then it becomes R. But otherwise, just you applied it and you claim it to be your own. Also, you can claim it as a TM. Okay, then it can claim as a TM. So basically, what are the conditions for this registering trademarks? It should be distinct. For example, no, my kids, they're small, so 3 years old, but from a long distance itself, they'll say, okay, father, I want to go to the McDonald's. So I will be, okay, where is this McDonald's? I can't see it. Okay, then, okay, what is the symbol for McDonald's? Can you just, one of you answer? I hope, because you are listening, not sleeping. So can you tell me what is the symbol for the McDonald's company? Hello? Are you there? Are you able to hear? And one of you just
Yes, sir.
yeah, what is the symbol for McDonald's? Famous symbol.
Sir, capital letter M.
Yeah. So what is capital M, but not in the traditional M, but it is what is known as the golden arches. Okay, so M in yellow color in the form of arches, 2 arches. So that is a notation. So I would be just on my niece would be saying, or my daughter is saying, okay, where is I'll be just checking, but they have already identified that notation. So that is the distinctive logo. So you give it, and it should, but at the same time, it should not be deceptive. So this is a very important thing. So I'll give you an example. So these are, sorry. So this is these are the for Nestle. This figure of this Nest and immediately Bata. Okay, Tata. You have this so Usha, NBC. So some just standard logo which popular, which many of you might be knowing. So that is why I've given some examples. So this is distinguishable and unique logos, and the letter, both the writing and the symbols. So you have figures and symbols, and how this, for example, Usha in this box, and you written in this specific way, not in italics or in other one, but in this kind of way. And then there's a statement, it's a better life. So but this you can write, it's basically BATA anyway, you can could have written, but when you write in this form, it becomes a unique identity for that company. Okay, so when you're starting a company, this is very have a trademark. Okay, so one example that I'll give is this, there was a company in Kerala, the construction company called uh, uh, Apple Constructions. Okay, so we know the electronic giant is there, Apple Inc. is there. So this company, this construction company, they had even their own websites, and this name and logo is there, and almost like an Apple itself, their logo also. So what happened is, Apple company people, they realized, they noticed that many people are getting deceived, or when they're searching for Apple product, they're going to this company, construction company's website, their logo and things. So a lot of confusion. So immediately they filed a case, lawsuits, and saying that, see, you have copied our name and logo, we had filed this before, so please change it or pay so much legal damages. So immediately, the unfortunate, by changing the whole name and coming with the new name would be very expensive. Now they already branded themselves. So this company people, also construction company, also very smart people, they renamed it as Apple A Day Construction Company. So a small change they bought, and tried to save the company. Unfortunately, the company no longer exists because of a lot of other lawsuits now, not timely finishing their flats and things. They have closed down. But as I told you, so this this is just one example. Many companies, they even started releasing their product, and then they found out this name already exists somewhere else in USA or Europe, and they would be filed, a case would be filed against them, and they were, unfortunately, they had to rename. So whole branding, so basically when you're coming with a company and a new product, so much branding, advertising, so many things have taken place. You have to change the whole thing, all the legal documents have to be changed. So basically very, very expensive and costly affair. So companies are, unfortunately, many have to even close down. So don't do that. So if you are, especially those are coming with startup companies, please make sure you have a very unique name, brand name. Get it registered it should not be distinguishable. So this is an example, two companies, Prill and Brill. Okay, so the name is almost same, the bottle shape is almost, so if this company, okay, identifies that this is a copy, they can file a case also. So this is another example which so the cost and things, which again, 10 years basically term for trademarks, and can be renewed indefinitely for 10 years, fortunately. Okay, so because companies cannot keep, after 10 years the name goes, then they cannot exist. So every 10 years they you have to renew. For a marginal, very small fee you have to pay. Okay, so apply again, sorry, yeah, second. Yeah, so this I'll not. Okay, the other things again is GI, that is called as a geographical indicator or indication. Okay, so basically from the name itself, for it is for a particular geography. Okay, some connected with some place. Okay, one very famous example, so without having to, is our Aramula Kannadi, especially for Kerala. Okay, or Balramupuram silk. Okay, so these are some products. Okay, so the silk or saris or dresses or veshtis are or famous from Balramupuram. There's a class of craftsmen or weavers who are making that particular saree. So you can, somebody can Kanjipuram silk is there. No, there's a this again. China had brought this in weavers from Kanjipuram district to there to make this silk, and now China is also can also make this kind of. So this to prevent such kind of malpractice or the loss of livelihood of this traditional craftsmen. Okay, this GI was brought. Even not even craftsmen, even it could be farmers or trades. Okay. So any kind of craft, it could be metal works or and weavers or basket makers or something, which is some specialty of that area to protect that. So there we know this Kanjipuram silk or Balramas have particular region, this GI was brought in. Okay, so some examples: Darjeeling tea, Kanjipuram silks, Nagpur orange, Kolhapuri chappals, Agra peda, Goa feni, Palakkadan matta, Navara rice. So many. This is just a few, more than some 50 or 60 GIs are existing in India. So these are examples of GI. Again, any who can apply, any association of person or producers or any organization or authority established by or under the law representing the interests of the producers of the concerned goods. Okay, they can apply for GI. So not just one person, even a group of people, maybe it could be family or non-family organization or anything. Okay, but they have to say that we have been doing this for so many years, more than centuries. We have been, our ancestors are doing, or this group of people are doing, and you can protect that. Okay, and it is for 10 years, term is 10 years and can be renewed automatically after every 10 years. Yeah, so trademark and GA, okay, we'll not okay, so the cost and things, okay, again, not going to. So the fifth one, this is actually very easy. Patents are very rigorous. Okay, so sometimes you may not come with a new product, but no, the existing product you can come with a new design. Okay, so we, in this case, a new act has come in post 2000, that is Design Act, or what is called as industrial design or design patent, sometimes called as design patent. So design patent is for the appearance of the article, not how it works. Okay, so the basically dealing with the aesthetics. Okay, and term of 10 years and can be extended for another 5 years. So total 15 years you can get for this industrial design. So this is much more easy. So many time you come with for the same example here, you can see an electric heater or some jar or something like that, electric kettle. But the appearance, you can see here, corrugations are there, the handle is provided. Similarly, in the case of dress, fashion industries and things, this, they can also file for and yeah, so basically having anything, so the design, yeah, Yeah. So this is again, this is also very important. So you're coming, especially for startup companies, you are coming with a new product. You can the working of the invention and things that you can file the patent for your company. You go for a trademark and things like that. And the appearance, okay, so same product can be made by two or more companies, so then the appearance also will play an important role. Okay, so in which case you can file for this design act, and these are the cost. Basically it is in Kolkata you have to apply for this. Okay, renewal can be done in Chennai also. Okay, that's the. So the sixth IP, we have another two more IPs, so we'll quickly finish. So the sixth is the layout design. So those are work again. This is again exclusively for you, for the electronics club, which is organizing today's session. Many of you are coming with new chip designs and things. So semiconductor layouts and transistor and circuit IC layouts, you can file for this. This basically you cannot file patent for ICs in India. Instead, you have the different IPR for this, exclusively for the layout design of integrated circuits. Okay, you cannot if it, but it has to be original, and it should not be have been commercially exploited anywhere in India or any other country. Or a convention country. So the convention countries, there is something called as a PCT, Patent Convention Treaty is there. About 120 countries have signed that treaty, and those countries, in any of those countries, USA and others are also involved. So if it should not have been filed in those countries, patent or any other IP in that country, and it should be distinctive and distinguishable. With these three conditions, you can file for this working in or interested in this area. Don't file for patent, but rather go for this IC layout design. Okay, and fees is 5,000 rupees. You have to file it in the Delhi office. Okay, only one single form, very easy to apply. The last one, seventh one is protection of new plant varieties and farmers, right? Again, not related with engineers. So just quickly, that is basically for those so many new plant varieties. People do genetic modifications and come with these new kinds of plants and other agricultural products. So in which case, again, will not be awarded a patent, but there's another IP called as protection of new plant varieties and farmers' rights. Okay, and in our case of trees, vines and things like that, people do file patent for this. Okay, so fees and things like that, again, I'm not going into detail because not that, but you should be aware that this is the seventh IP. The last IP, yes, so with this we'll be concluding, that is the trade secrets. Okay, uh, trade secret is basically related with manufacturing. So many time, some formula or chemical compound or a process of manufacturing, you can actually file for patent, but some new technique which you want to hide, okay, you can file for trade secret. So basically it's not very unless IP office will examine thoroughly whether it is really worth. So you say that your compound or combination is worth which should not be copied. If it is revealed, then anybody can manufacture it. Okay, in which case you can file for trade secret, in which you don't have to give any information about your product, but you can directly get file a trade secret and keep your product as a secret. Okay, so the best example of this is the Coca-Cola. Okay, Coca-Cola product, nobody knows what is the of course by different techniques, but how this combination, what is the combination, how it is, what is the order in which it has to be manufactured, that is kept secret. So it's a very, even now nobody knows, both for Pepsi as well as Coca-Cola. So you know, because why, because this was trade secret was one of the main reason is the the cola wars that is between Pepsi and Coca-Cola. The no product is almost same, it's basically soft drink, Coke is there, but Coca is there, but in some different combination. Okay, cool drink basically. So if one competitor knows this is the composition and this is the way in which it is being, then the other person can easily copy, and the whole the company can get closed down. So that is why this trade secret option, but not a very favorable IP. It's not advisable, or unless it is an IP, patent office will assess whether it is really worth, then only they will assign this IP. Okay, so the summary, Okay, so for example, a television. So in the case of television, the invention, the television has a patent. Then this is a company Sony. So the trademark, the way in Sony is written. Okay, so that is a given trademark. Then the appearance, so design will be given a patent, design patent. Then there's some circuits, IC circuits, and for the picture display, sound, and things. Circuits will be used, for which you have to find the IC design layout patent will be or design IP will be able to find. Okay, so many things are required, for the end product to come into the market. So many IPs have to be filed. If any of this is not filed properly, then be sure that somebody else will file a case against you, and the whole product will have to be closed down. So Samsung and Apple, the famous war between them regarding the phones, a mobile phone was there. That only finally Samsung finally lost the case, and but they had to actually, for us it may be a big amount. For Samsung, finally it was nothing, because they made more money from the sales of the product. Anyway, so this is another one more example. You can see this parachute, famous product for coconut oil. So the design has been filed for these three different. You have the bottle, traditional bottle is there. Then this middle product is there with a narrow opening is there, or broad opening is there, and this is a sachet is there. So all these designs have to be filed. For the second one, the middle product, you can see this is a special patent has been filed for this product. Why this is? Because in North India, we have cold climate and things like that. So coconut oil basically will freeze in cold climate. So in which case, if you use this bottle, then you cannot use there. So that this opening, a broad opening has to be given in case of winter season to take out this coconut oil. So that design has been given a patent. The name, you can see the parachute, the name and how it has been, the name itself, the word parachute, then how it is written, and also this logo of a coconut tree in the center. So that has been given, a trademark has been given. The name has been given, copyright has been given. So many IPs, so much IPs are involved in a very small product like this. Okay. So basically, anything from your mind or intellect has come, that is considered to be property, and as per the laws, it's a right to the inventor. Suppose an idea which comes in the form of expression, then becomes a copyright. Idea in terms of innovation and invention, it becomes patent. An idea which has come to your mind and finally comes in the form of output of a quality and identity, it becomes a trademark. Idea in the form of an appearance comes as a design IP. Idea, if you don't want to disclose, keep it confidential, it becomes trade secret. So this is the summary of the different IPs. Those are from CET. We have an IP office which is located in the your hostel office. Currently, it is in the near the hostel office, next to the NSS room. We have an IPRC. We are the satellite center for the IPRC, or the IPR Information Center Kerala, which is located in the Kerala State Council for Science, Technology and Environment, KCST. So their office is in Shastra Bhavan, Pattam. That is just opposite to the Kendriya Vidyalaya Pattam school. They're just opposite this KCSC office there. In the first floor, you have the IPR center is there. So you can get all information regarding things. Also, they also help in facilitating for filing and things like that. In the actual filing, they will not do that. You have to do it on your own, or find a patent attorney and do it. But the pre-stages help you to whether for patent searching and things, whether your product is novel, identifying that, and although that those help, they will help give us. Okay. And this is the contact details for that. So with that, I am concluding today's session. Thank you very much for giving me an opportunity. I hope the session was useful and you had understood. Now we can have the session open for uh, discussions. Okay, so if you want to have any, you have any questions to clarify, okay, please let me know. Whatever information I have, I'm gladly I can, no, I will give it to you and share it with you. So admins, so we'll open the session for QA. I hope the voice was clear. if any session was any part, the audible part was a problem was there, audio problem, please let me know. Maybe I can again go through that also. No issues. I am perfectly fine, but students can decide. Admin, hello, Arda. Yeah.
Hello.
Yes, sir.
Yeah, yeah.
Now the session has come to end. Thank you, sir.
Anybody having questions regarding IPs, any of the IPs or patents? So why I have taken all the IPs basically for no. Many of you might want to start a new company or something, so you should be aware. As I told you, not filing any particular IP, for example, design or no trademark, can be a costly, end up as being a costly affair. But no, most of you might be interested in purely patent filing invention. You are not planning to start a company as such now, but maybe in future you might do it. But now, if you want regarding patents, you can ask now. So always regarding patents, as I told you, it's a techno-legal document. And before, whether to know, many of you might be having a doubt whether the idea is or the product that you are going to come, whether it is novel or not. So do a patent search. Patent search, KCSC will help us do a free patent search. Also, you can, as I told you, you can do on your own. Use Google Patent to search for. There are some other free softwares on our websites also which help in filing regular some sites are there, for example Derwent Technologies is there, so you can register in there, and they will also, you have to just give your email ID and things like that, register it, and there also they do a patent search. That is more actually, but the other sites they give some more area wise and other similar ones and things like that. Google Patent also gives, but little more user friendly sites are also there. That's what I just want to say. So do a thorough patent search first, which will establish that your work is new and novel. Once you have established it is new and novel, then you can be confident, no, filing patent. Yeah.
Excuse me, sir. Excuse me, sir. So there's a
Yeah.
question
Ask.
in the chat.
Okay. 1 second. Sorry.
So it's about some idea, and he doesn't know how to take it forward, and he's asking for some steps for that.
1 second. Yeah. Thank you. So I have an idea, but I don't know how to forward. Yeah. So you basically again you don't get a patent for an idea as such, but for an end product. So the idea you the first, I think one good suggestion that I can in this IPR IPRIC Kerala site website you go, there's a patent facilitation form is there. Okay, this patent facilitation form you please in the IPRIC center, you just website you go and download that patent facilitation form. You start writing. An idea is just something in your brain, so that has to be finally come into a product, and before going to product you yourself write down what is the things. So that form when you download, they will tell you, okay, write the abstract, then give the specifications, what are, please include drawings, okay, give a detailed methodology of how it is. So when you start writing it down, the idea starts coming into fruition. Okay, so in that way you can it's there, you do a patent search and see whether it is novel, and then we can of course file for patent. And if you are fast Fudel, if you are from CT, you can anytime come to the IPSL or contact me, and no, you can always, I will tell you the okay. Second is Archa has asked, will I get paid if someone else is using my patented ideas? Yes, in the sense of course that person has to take your permission, then yeah. So as I told you, why we are going for patent is to get money, not just because you have want to commercial. All people may not be having the entrepreneurship ability. For example, Tesla did not become a successful inventor. He was a very prolific and successful inventor, but not a entrepreneur. While at the same time, Edison was actually an average inventor. Okay, but of course, in terms of invention, he has the maximum number, almost equal to Tesla, more than Tesla. He has got one of the two persons who have more than 1,000 patents under his name. But of course, it was a team also. Many of the inventions are not directly by Edison, but a team of members. So we give credit to Edison because one or two are his, especially bulb and things. But apart from the other things, it is a team of people who have come with the invention. But the difference was Edison was business-wise was very shrewd. Okay, and his company has flourished. So therefore, he did not have any economic crisis, while Tesla almost died poor. So there, because he was not good. He was more of a free thinker. He just wanted to come with work. So yeah. So here also, you can decide whether you want to start a company or not. That is entirely up to you. But the invention that you are coming, make sure that if somebody else, you can get a commercial value from that this by 2 or 3 ways. Either you can directly, the patent that you have, you can sell it as it is, sell your patent to a company. But then the problem with that is today 1 crore may be a big amount for you, but say 10-20 years, we don't know whether 1 crore, because of the inflation things, 1 crore may not be a big amount. Today 1 crore may seem a big amount, but 20 years down the lane, 1 crore may not be a big value. So it is always therefore advised, okay, so to license your patent. So that is, you say, okay, for 5 years I will grant the ownership rights will be granted to you, provided you give me a yearly this much amount. So you get a fixed income every year. Okay, so like say 20 lakhs, you say. So every year you get 20 lakhs or for 5 years. And if then later after 5 years, you can increase that amount, say from 20 years per year to say 30 lakhs or 50 lakhs per year. So in which way you get a better amount and a steady income over a period of time. So the other one year, 1 crore you get, and you might just spend it also quickly. And that 1 crore, as I told you, may not have any worth after 20 years. The other one, by licensing, you can get for then amount for regularly for a larger period. So that is how you get money from the patent office. Okay. So so it's yeah, so that, I hope that has answered. You get, yes, you get paid if but of course by as I told you, there's again a catch here. That is, if you have not filed your patent, say in China, and your invention is really good, China can some company in China can manufacture it. They need not pay money to you. They cannot get patent. That's all. Because of the Patent Treaty Act, the Chinese, that company will not be granted the patent either by China. But no, China feels that there is an economic worth for their invention, get by manufacturing this, and they find that it has not been patented in China. They can close their eyes and allow that company to make the product there, and in that case you will not get money from that patent. But that is another for somebody starting a company, find out the commercial worth also. So you feel that product is worth in Europe, or you have, for example, European patent is there, which is valid in some 20 the European Union. Then US patent, you feel the product is valuable in US, then you'll have to file patent in US also. Okay. Similarly, Australia and other countries, so many countries, depending on the nation where you feel you want to commercialize your product, you'll have to file it in that particular country. Yeah.
Hello.
Yes.
A feedback form is given in the chat box, so please everyone fill the feedback form and give us a valuable comments, please. Once again, if you have any doubt regarding the topic, feel free to raise them up. You can ask your queries directly or make the chat box for the same. You can ask your doubt about the session to the sir directly. I hope the topic is clear to all. So, guys, this session
Uh,
was an informative.
yeah, Arta, just 1 minute.
Okay.
There's a question raised by I believe Fudel. Fudel, is he there? Still there? Mohammed Fudel. Uh, he has asked whether he had an idea. Are you from CET?
Hello?
Fudel ഉണ്ടോ?
Hello?
Are you from CET?
Sir?
Yeah,
അതെ.
Fudel, I'm
No,
able
no.
to hear. CET എന്നാണോ? അല്ല.
അല്ല അല്ല അല്ല. I'm from
കുഴപ്പമില്ല.
Model
ഫുദേല്
Engineering College.
ഡൗട്ട് ഉണ്ടെങ്കിൽ പിന്നെ ഫോൺ വിളിച്ച് ചോദിച്ചാലും മതി എൻ്റെ അടുത്ത്. ഓക്കെ
Okay, sir.
ഓക്കെ ഓക്കെ ശരി.
Number
നമ്പർ വേണം അല്ലേ? ഓക്കെ ഓക്കെ. സോ ഐ ജസ്റ്റ് put my number. Yeah, so this is my mobile number. Please note it down. You can call me and clear it out. Yeah, that's it. So Arda, you can continue. Thank you.
Okay, sir. Once again, I thank you for giving such a wonderful session. Thank you, sir. And for all those bright minds. Okay,
For
thank you,
giving
sir.
the opportunity.
Welcome. For all those bright minds brimming with ideas, let us not get them wasted. Bring them out and create new. Wish you a wonderful evening and good night.